All right, good day. Welcome, everybody. Thank you for joining us for Valuing Real Estate Assets. My name is David Levy from Keen Summit Capital Partners and Summit Investment Management. I'm your moderator today. This webinar is part of the Financial Poise webinar series, Ethical Issues in Real Estate-Based Bankruptcies. Slides 7 and 8 provide a summary of the series and episode. Speaking of the slides, you should understand from the get-go that we will not step through the PowerPoint in order, nor will you have to listen to us read on any slides. This webinar, like all Financial Poise webinars, is a conversation. However, keep the PowerPoint handy because I will try to indicate what slides our conversation is touching on as we proceed so you can take notes. Our panelists today are Samantha Rubin, an attorney from Denton's in Chicago and a member of the firm's restructuring, insolvency, and bankruptcy practice. Matthew Christensen, a certified turnaround and restructuring leader from Amplio in Boise, Idaho, who was previously a longtime attorney practicing commercial law, bankruptcy, real property, and business matters. And Mark Silverman, an attorney from Troutman Pepperlock in Chicago and the firm's commercial mortgage-backed security known as CMBS team leader. Again, I'm David Levy from King Summit Capital Partners, and we provide real estate brokerage services, auctions, lease restructuring, investment banking, and more for real estate in special situations. Our parent company, Summit Investment Management, buys all kinds of distressed debt and provides bridge and bankruptcy financing. We appreciate that you're not spending your time and money to attend this webinar and hear infomercials about us, but you can read more about us in slides 51 through 54 of this presentation. This webinar is a production of Financial Poise. To sign up for a great free weekly newsletter, go to financialpoise.com/subscribe. If you're attending the live premiere of this webinar, you can submit questions via the web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just so you include your name and your question in the webinar episode you are referring to, and we will do our best to get you an answer. And special thank you to our co-producer, the National Law Review, a premier legal news website offering in-depth analysis on a wide range of legal and business topics. Okay, as the legendary Jackie Gleason used to say, away we go. So today, of course, we're going to have an important conversation about ethics and specifically ethical issues in real estate-based bankruptcies stemming from valuations. Our cast of panelists will speak from a variety of perspectives based on their professional background. Samantha Rubin from Denton's and Mark Silverman from Troutman Pepperlock both specialize in creditor and lender representation, and Matt Christensen, the certified turnaround and restructuring advisor from Amplio, but who was previously a longtime attorney, will play the part of an attorney representing the debtor. So let's start with a good warm-up question and begin. What are ethics? Samantha, start us off.
Thanks, David. So ethics can apply both to business folks and lawyers. Sometimes there's actual legal liability, such as for fraudulent transfers or unjust enrichment. And sometimes the situation may not be, per se illegal, but it might strike some as questionable. The legal term for that is the gut check. Sometimes you just know, you just feel it, something is off. In the world of financial distress, there can be many aggressive participants on all sides, and these questions are frequently raised.
Thanks, Samantha. Matt, what do you think?
I kind of echo what one of the things that Samantha said, the gut check rule. Ethics themselves are what's the right thing to do, essentially, whether it's legal, whether it's illegal. Hopefully, if it's illegal, it's not the right thing to do. But generally speaking, how do you want to be treated, and how does that then impact how you're going to treat the other people that you're dealing with?
Makes sense. Mark, what can you add to this?
I look at it the same way I tell my kids. Legal ethics are very much doing the right thing when no one is watching. And it's the overarching body that governs all of us that are practicing attorneys. And you have the cover of attorney-client privilege, which can give you certain abilities to change things. Don't do that. Be truthful, be honest, be forthright, and advocate zealously for your client. The facts are the facts. Changing, massaging, and otherwise making things more difficult for yourself is not going to benefit anyone in the long run. And in fact, negatively implicates your just overall ethics and your perceived overall perception in the market. So be a good person, be a good human, even when no one's watching.
Yeah, what I would add, I am the non-lawyer in the group. I'm just the real estate guy. But I will never forget, I saw a presentation from Andrew Fastow through the local Turnaround Management Association Chicago chapter many years ago. And he stood before us and he showed a picture of himself on the cover of CFO magazine. And he showed us a picture of his ID from when he was in prison. And he said, I won both of these for the same set of activities. And as I was doing my time, I came to accept that while every action I took was approved by our attorneys and approved by our board and approved by our bank, I knew collectively they were creating a giant fraud, and therefore it was both illegal and unethical. So sometimes we've got to keep our head on straight about these things. But we're also delving deeper into the combination of the two, the concept of legal ethics. And the American Bar Association, or the ABA, provides a framework for ethical questions called the model rules. And I'm curious how they influence your individual practices. Matt, give us your thoughts.
So the model rules that the ABA puts out are a series of rules dealing with how attorneys are expected to act with relation to other people. There's rules dealing with you and your clients. There's rules dealing with you and the court personnel. There's rules dealing with you and unrepresented people or opposing parties. And so each of those rules is pushed out by the ABA, but gets adopted in some form by every jurisdiction in the country. So no matter where you're licensed, you're governed by some set of legal ethics rules. I think a lot of the rules are similar to what we just talked about. Like, this is the best practice for dealing with people, dealing with your clients, dealing with information. There are some that are very specific to law practice and confidentiality of information and that sort of thing. But generally, that's the body of rules that governs the way attorneys are supposed to act. So it's not the substantive law, but it's the way that you're supposed to act and deal with people.
Thanks, Matt. Mark, please give us your thoughts.
Yeah, so I think I don't want to repeat what Matt said, so just adding to it, it also governs use of technology, which is becoming increasingly challenging as we deal with generative AI and other AI tools in the practice of law and what clients are using in their delivery and asking for legal services. So just be reminded that all lawyers have the obligation to stay abreast of all technological updates. And so if you think of kind of the major technologies that have occurred over our careers, it was from books to digital Westlaw and digital Lexis. I think I may have been the last class in law school that still had to do research in some books. The rest of them were all online, and we still had like Westlaw credits and Lexis credits. But the duty for all practicing lawyers at that time was, regardless of the fact that for the last 30 years they were looking at books, they now had to look online. And so now we're getting into an environment where Westlaw and Lexis and all of the other tools are using generative AI, and then you have the courts that are issuing opinions saying, hey, these are hallucinated cases, and you can't or shouldn't be using generative AI in the delivery of briefs, etc. So I think there's going to continue to be evolution surrounding this. Where it impacts real estate is going to be probably on the appraisal side most readily, because if you think of a perfect use case is upload a bunch of comps into AI of some sort and ask it to create values for you, and doesn't necessarily tread on attorney ethics, but perhaps in your world, David, when you're an expert witness or when you're dealing with complex real estate transactions, this is somewhere where I can envision the intersection of AI and ethics coming into play. So just continue to learn technology.
Yeah, look, this is a 3-part series, and I'm the real estate guy. Everything we're talking about was inspired by situations I've encountered over the years as a special situation real estate broker. And episode 1, the valuation. Sammy, what's your take on the model rules in practice?
Yeah, just quickly, I would just reiterate that the model rules are very important to what we do. I don't know if Matt and Mark remember this from law school, but you take a whole class on ethics, and then you have to take a separate test in addition to the bar exam on ethics. And if you don't pass, you retake it, which I will say a lot of people did have to retake. It's a very serious part of becoming a lawyer. So it's, it's at the forefront of our minds when issues arise, but always in the back of our minds as well. And I will say, in terms of the bankruptcy world, when I'm at least on the debtor's side, for example, in a case recently, it was a healthcare case. I was the contact for all creditors and residents of the nursing facilities, and so I was being contacted by a lot of folks who were not familiar with the bankruptcy process or really maybe had even contacted a lawyer before. And so one of the things we'll talk about later too is contact with unrepresented people and making sure you make clear if there's any ambiguity that you're not their lawyer, and to be careful about how you convey information to them, and suggest that they even get their own lawyer if if it's getting a little gray. So that's one way that comes up in the bankruptcy space, but I think we'll talk about that a little later.
Sure. Well, I'm up to slide number 12, as you can see, and wanted just to go over some of the model rules that will be discussed today, which include Rule 1.1 to 1.3 about the client-lawyer relationship, and rules covering competence, scope of representation, and allocation of authority between client and lawyer, and diligence. Rule 3.3 to 3.4 about being an advocate, rules covering candor towards the tribunal, fairness to opposing party and counsel, and Rule 4.1 to 4.3, transactions with persons other than clients, truthfulness in statements to others, communications with persons represented by counsel, and dealing with unrepresented persons. So moving right along, Matt, talk to us about valuations and how they're used in bankruptcies, and what might each side's interest be on this topic?
Good question. So from the debtor standpoint, the first thing you have to do is file your schedules with the bankruptcy court. Those schedules have to list the value for your assets. So I think that's the first place where that comes up. The debtor swearing under oath that the schedules are correct, so you want to make sure the values are as close as you can be. As the case progresses, there may be adequate protection issues that come up and valuation disputes there. There may be a sale hearing where there's an asset being sold and the value that's being received for that sale is challenged. When you get to plan confirmation, the confirmation of the plan requires some kind of liquidation analysis, and the valuation of those assets may be contested in the context of that analysis. So from the debtor's standpoint, there's times where the debtor's goal may change, right? In an adequate protection standpoint, I want the value of that asset to be really huge because there's an equity cushion there, and that's your adequate protection. Is there's enough value.
In that, will you define adequate protection for us?
Adequate protection is if you've got a secured creditor if I've got a piece of real property and that secured creditor has an interest in the real property, or better yet, let's say equipment. I've got a piece of heavy equipment that I'm using, and that lender has a lien on the equipment. My use of the equipment is gradually degrading and depreciating that equipment value. I have to provide something to that lender to help protect their interest in that piece of equipment. It can be an equity cushion, and that's where the valuation dispute comes in. Maybe I have to make a monthly payment, whatever. But the key is for the debtor, at that point in the case, I want those valuations to be really high because then it's equity cushions and that's your adequate protection. Well, later on, when I get to confirmation in my liquidation analysis, I want the values to be really low. And so there's this if the case doesn't last very long, it's hard to explain later why your valuations are so significantly different on those two charts. Creditors' interest in an adequate protection scenario is, they want money from the debtor. They don't want an equity cushion as their adequate protection. They want cash. And so the lower the value, then that matters. In a sales scenario, the debtor wants as many creditors to be paid off as possible with that sale. So their interest is getting an actual good value. I think that may be one of the few cases where everyone's interests are fairly aligned. We want to get the highest and best value for this asset, unless there's some weird insider trading or fraud stuff, which I think is a whole separate seminar later this year. So there's different reasons for each side to advocate for different values.
Okay. And Mark, what are some of the most common ways to value real property?
So we typically start with BOVs, broker opinions of value. In this current market, that seems to be a little bit more reliable than the second way, which is MAI appraisals. Appraisals are going to run through a much more regimented process than a broker's opinion of value, and is technically the gold standard when you're going to be valuing assets, especially when you're dealing with valuation fights in bankruptcy courts. But more and more frequently, we're relying more heavily and putting more pressure on BOVs than we are on appraisals. The sales that are occurring in the marketplace aren't as consistent. And so because of that, some of that data is a bit stale and can put their thumb on the scale one way or the other. And the brokers are able to get us a little bit more detail as to what it may go for if marketed to the right group, or if the right things take place, or if it's converted, or if it's not converted, or if you convert part of the building from one asset class to the other. So in my view, BOVs tend to be a little bit more reliable today. That might change down the road and pivot back to appraisals, but I think for right now, that seems to be where things are headed.
And so, Mark, you can navigate through a bankruptcy hearing on this topic, either through an appraisal or if a broker is testifying about their broker opinion of value analysis?
You're going to need both. It's because the body of law isn't necessarily caught up on BOVs, you're still going to need an appraiser, and you're still going to need someone that's going to be able to testify at that. That's what this code is written around, and that's what the case law is all incorporates appraisals into the mix. So I think you would ultimately need both. But BOVs are necessary, and I think you would get a broker to come in and testify in addition to your appraiser or your appraisal expert. And then I think you'd probably want to find a third person to come in and say, hey, we've now looked at the appraisals and we've looked at the BOVs, and based on my experience in valuing real estate, here's what I suggest the actual value of the property to be, or the business, or whatever you're dealing with. So I think I think it's important to look at both, to have both, and to make sure that you have a third person in mind that can view both of the outputs and give you a decision.
I like it. Any other comments on how to value real estate? Things like offers that may have been received or financial modeling? Okay. And ultimately, Samantha, question for you, based on what Mark just said. How do courts ultimately decide on matters related to real estate value?
There's a couple of ways a court can determine the value of real estate. I mean, first off, it has to be in front of the court. There has to be some dispute or reason why the court would need to value the real estate. And, going back to what Mark said, if there's been an appraisal, the parties will typically put on an expert witness to testify as to the value. And then, and the appraiser will also discuss the method of valuation that they used, which could be, any of these listed here. And sometimes you have competing appraisals, and there's an issue. So I was recently involved in a case where the property had been appraised in 2018. The property was subsequently put into foreclosure in, I think, 2023, and then they filed bankruptcy in 2025. So by then, the debtor was using that 2018 appraisal, but things have changed. So both the lender and the debtor both hired their own appraiser to do, evaluation of the property. That's still in the court's hands, so we don't know yet. But the court will essentially, in these cases, weigh the evidence, look at the facts, and see, which method of valuation is proper, which appraiser, their appraisal was more believable. And then, one of the best ways I think to determine value is market value, the market test. What is someone actually in the market participant willing to buy the property for? And that's where, when you have an auction, that's usually a good test of value, good indicator of value. So usually I think that's the best way to determine the value.
Okay, thank you. Now let's put this all into action and turn to some case studies focusing on declining property value, appreciating property value, and a suspect valuation. Shout out to Samantha Rubin for putting together the fact patterns of these cases. Our case number 1 is on declining property value, and here is the setup. A limited partnership owns a Class C retail mall with a related movie theater and 2 casual dining restaurants in a declining, smaller Midwest town. The general partner is an individual who is guaranteed up to the mortgage debt, which was obtained at a reduced rate through a government revitalization program. The mall has been struggling for many years. Several tenants, including 2 of the anchor tenants, have gone out of business or reduced their space or negotiated for rent reductions. The partners have explored 2 options. 1, revamp the mall, including building senior living apartments in the vacant anchor tenant space. And 2, the other is to tear down the mall and sell the land for a new sports complex, and has an as completed valuation for the redevelopment option as well as a valuation for the raw land. It has shared the raw land and redevelopment appraisals with its lender, but has not disclosed to the lender that a non-binding offer to buy the land from the sports complex developer. The general partner lacks the funds to implement the redevelopment. One of the limited partners does, but is not convinced on the return on capital and favors a sale for the sports complex, which the limited partner is a co-investor in. The borrower also has offered to hand the keys over to the mortgage lender for release of the general partner's personal guarantee, but the mortgage lender is not excited about owning and operating this money-losing property. Counsel for the borrower has a substantial past due fee owed to it and has done work for other projects the general partner is involved with that also have past due legal fees. Counsel is not aware of the sports complex developer offer or the limited partner's interest in the sports complex developer. The mortgage lender has reluctantly filed a judicial foreclosure action and is seeking the appointment of a receiver for the property, but is in no hurry to complete the foreclosure process because it does not want to own the property and is concerned there will not be any attractive bids at the foreclosure sale, and that the wealthy limited partner may try to buy the property out of the foreclosure sale at less than half of the outstanding loan amounts. What are the ethical issues in play here? Is the borrower acting shady or shrewd? Samantha, what do you think?
Thanks, David. I think there's lots of things we could talk about here, but just a couple of quick points. So there are some fiduciary issues at play here for the general partner and the limited partner. So the general partner owes, fiduciary duties of loyalty and care to the limited partner in the limited partnership. And, under the facts, he personally guaranteed this mortgage and the property is in distress. So this creates a tension between, him prioritizing his personal exposure over the partnership value and, making decisions in the best interests of the partnership over himself. The limited partner also has a conflict of interest here. If he's a co-investor in the sports complex, and he also has the funds to develop that. So he's kind of teetering on the line here as well, depending on what decisions are ultimately made with the property and how he, votes if he gets a vote and what they ultimately decide to do. Also, the borrower has only shared selective information with the lender, only the appraiser for the redevelopment, but not the actual offer to purchase the land. So it's one of those classic situations of omission. Is omission lying? In this case, it's definitely a flag. it's perhaps not legally required for them to tell the lender about this offer, but they're selectively disclosing information, which I think is misleading.
Makes sense. Matt, what do you think?
I agree with those things. I think the attorney probably has an issue because of the past due fees and the work that they've done for other projects that the developer has an interest in. That there's no bankruptcy case involved yet, and so it's probably not as big an issue, but they'll have some employment issues if they try to get employed in a bankruptcy case. The other point I was going to make too is the non-binding nature of the offer from the sports complex people. From the lender's standpoint, I wouldn't necessarily care if you've got a non-binding offer to purchase the thing. So the lack of disclosure of that to me is less of an issue. I think the fact that it hasn't been disclosed to the attorney is a bigger issue to me than that it hasn't been disclosed to the lender. Because my experience with most lenders, when you paint a rosy picture that, hey, we've got this person ready to buy the property, and they say, well, send me the commitment letter or send me the purchase agreement, and you say, well, it's just this non-binding LOI that is a half-page deal that we have, and they basically say, well, then I don't care. And so that's why to me it's not as big an issue. If they had a binding purchase offer, that'd be a better thing, and hopefully that's something that they would pass on to the lender. So the biggest issue I see is just those disclosure issues, that they haven't told their attorney everything that's going on.
And Mark, what are your feelings on this one?
Well, since they've both covered everything, I'm going to take this in a new approach, given that it's January 29th in 2026, and the Illinois Uniform Commercial Receivership Act came into place January 1 of 2026. So I'm going to reread this this prompt here as a small Midwest town being in Illinois. And I'd say, hey, lender, we've got this new law that gives you the ability to effectively run the equivalent of a 363 sale through a receiver. So rather than being all glum that you have to foreclose and potentially take this asset back, why don't we put in a receiver under the new Illinois Receivership Act and run a marketing process, see what we can find, and see if we can find a buyer and jump directly to a third-party bona fide purchaser as opposed to potentially taking this thing back into title. So not an ethical answer, but rather just a practical strategy answer, since Sammy and Matt already covered everything that I could possibly think of on the ethics front.
Well, Mark, what if we change the fact pattern? What if counsel has heard rumors about the sports complex developer offer from others, but has not asked his client or the limited partner about it yet? How does
Back to what Sammy said, omission is not your friend here. And so if the attorney has this knowledge and heard the rumors and at least doesn't ask, that not asking is potentially very problematic for the attorney. And from the lender side, if the lender got wind of this vis-a-vis news articles, they're going to be asking about this too. And it's pretty tough to bury your head in the sand. Imagine a Crane Chicago business article front page that hits on this topic, and everybody just continues to carry on with the case and the process as if that article doesn't exist. It's problematic. It's not realistic, given that most attorneys are looking at that every day, every other day, and have news alerts set for any of their properties and clients. So it's something that I am confident that the attorneys on all sides of the deal would be aware of, and shame on the debtor's lawyer if they don't bring it up with their client.
Matt, what's your take on this tweak of the fact pattern?
So I want to add one little thing, and that's if the counsel knows that there's or heard rumors of a completely non-binding sports complex offer, I may go to the client at that point and say, look, if you get a binding offer, let me know. But as long as it's non-binding and they don't actually have to do anything, I don't necessarily care either, because nobody else is going to care. And so I think it does require some conversation with the client, but I think it would be more along the lines of, hey, go get a binding offer from them. Even if there's, long due diligence periods and all this kind of stuff, but something that I can then take to the lender, because I don't want to take a non-binding offer and try and get them to postpone a foreclosure or appointment of a receiver or anything like that. It's not going to get me anywhere.
Just to add to Matt's point quickly and bring us back to the rules. So lawyers have a duty of diligence, and you can't provide proper advice without full information. So I think what Matt's suggesting would fulfill that duty, or at least asking the client, to keep you updated. You're saying you're aware of this rumor, without. I mean, the attorney should probably ask about it, but I think that would fulfill that duty.
I think one of the things as a debtor's attorneys that you have to do a lot of times is educate your clients on why it's okay to share information with the lenders. They're so conditioned to want to like hold everything close to their vest and not tell the lenders what's going on. And they're going to get a lot further and a lot more, maybe not a lot more, but more concessions from the lender if you're sharing information and keeping them informed of what's going on and what efforts you're making to try and get them repaid.
And Sammy, what if we change the fact pattern one more time? What if counsel's learned that the general partner has taken larger than market management fees in some distributions out of the property for the past 2 years?
Once counsel knows this information, they can't unlearn it, and certain duties are probably triggered. This is no longer a neutral fact. If the general partner is taking, larger than market fees and distributions, especially when the property is distressed like it is here, this might move into the self-dealing breach of fiduciary duty territory. And I would probably advise him that there's a chance that these, if they go and file bankruptcy, there's a chance that these payments might be clawed back. So I'd want to advise him or her of that they might be vulnerable to clawback. The lender, it might weaken leverage with the lender if, the lender learns of these payments. And there could also be some potential exposure, personally, of the general partner. And under the model rules, the lawyers can't insist in conduct that they know is fraudulent. So moving forward as the attorney, I would need to be careful about how I advise the client.
Mark, anything to add to this new fact?
Absolutely. If I'm the debtor's lawyer, I'm going to be pretty upset that they're taking distributions and not paying legal fees. That's certainly problematic. Also, from the lender perspective, most of the time, especially in CMBS deals, you have approved budgets. And if the approved budget includes insider fees and those insider fees aren't disclosed, you potentially have recourse triggers, you have other issues that might pop up. But more importantly, if you're making and taking these distributions and they're not part of your approved budget, you potentially have further defaults and further issues with your lender. So I think you've triggered a whole host of potential issues for yourself.
And Matt, do you have anything else to add to this change in fact pattern?
The only thing I'd add is this is further grounds to have the receiver appointed. Mm-hmm. If the lender finds out about it, they're absolutely running to the court saying this is another reason why we need to get that receiver in place to pursue recovery of those things.
Sure. Well, Mark, let's go back to the model rules. Please give us some thoughts on how Rule 1.3, diligence client-lawyer relationship, and Rule 4.1, truthfulness in statements to others, apply to this case.
Those are the relevant rules. I think Sammy touched on 1.3 at the outset, but you do have a duty to ask these questions, especially given all the news that may or may not be swirling around the potential sale. You've got to ask the questions, and your client has a obligation to tell you the truth. And if the client's not going to tell you the truth, you as the lawyer need to reconsider your attorney-client relationship and whether or not that's something that you want to continue to participate in. So 1.3 is going to be important, and it ties in nicely with 4.1, because if you're simply just burying your head in the sand, not asking the questions, and then not reporting information to the other side, that omission is loud and is violative, in my view, of Rule 4.1. You didn't do the digging, you didn't ask the right questions, and therefore you couldn't possibly tell the truth. So I think the tie-ins between these two rules are fairly significant.
Okay, well, let's move on to our second case study, appreciating property value, which starts on slide number 22. I will review it. Two real estate developers own an upscale business-oriented hotel acquired through a limited liability company in 2019. The hotel did very well and was cash flow positive before the COVID pandemic, but required closure of the hotel for most of 2020. When the hotel reopened, occupancy, events, and room rates have been much lower, but improving slowly over time as conferences and meetings pick up. Although margins have remained compressed given inflationary pressures, forcing certain trade creditors to be stretched and management fees owed to a related property management. Let me say that again. Owed to a related party property manager to be accrued. The hotel is subject to a $100 million senior mortgage and more recently, in 2022, a $20 million mezzanine loan secured by the developer's equity of the LLC. Both loans are non-recourse, but the mezzanine loan has a quote-unquote bad boy guarantees if the LLC files for voluntary bankruptcy or encourages an involuntary bankruptcy to be filed against it. The mezzanine lender also required that the LLC add an independent member who would need to approve any bankruptcy filing by the LLC. The LLC has a 2022 appraisal showing both the senior mortgage and the mezzanine loan are well oversecured with significant equity value to them. There have been few comparable hotel sales in the market since 2023, but there is one pending proposed sale of a competitive hotel nearby, which one of the developers secretly knows is unlikely to close. The senior mortgage has been in default since 2023, and the mortgage lender sold its loan to a private equity fund focused on the hotel space. The new lender immediately filed foreclosure action, and the foreclosure sale is set for tomorrow. The developers are also meeting with their attorney, who represents one of the developers regularly and also represents this LLC borrower, to determine whether to file bankruptcy and whether to propose priming debtor in possession or a DIP financing from the insiders or the mezzanine lender to try and obtain forced use of cash collateral over the new senior lender's objection. They have not invited the independent manager to the meeting, but are discussing strategies to threaten to sue or remove the independent manager if he does not authorize the bankruptcy filing and priming DIP financing. Okay, what are the ethical issues in play here? Is the borrower acting shady or shrewd? Matt, start us off. What do you think?
Shady, absolutely shady. There's, it's hard to know where to start. There's so much in this thing that I think is a problem. So I'll try not to hit everything so I can leave Mark and Sammy some things to discuss as well. The independent director that's a sort of commonly well-known problem, and the fiduciary duties that independent director has to the LLC versus to whoever appointed him as the independent director. There's always some conflict between those two things. From the borrower standpoint, though, I think having a meeting of the directors without actually telling the independent director that you're having that meeting, especially if you're discussing in that meeting something that independent director has a specific duty and ability to veto, it is, to me, is a problem. I think also the borrower's timing of the meeting, the developer's meeting, the foreclosure sale is set for tomorrow, right? And from a debtor's standpoint, that's the worst time possible to have this initial meeting with your attorneys, is the day before the foreclosure sale that you've known about for at least 4 months, if not longer. So the fact that they wait till the last minute to do it, and then they're going to spring something on the independent manager that afternoon and threaten to sue him if he doesn't agree to things, that just all speaks dirty to me. Whether there's actual model rule violations, but going back to just ethics in general, that's not winning you any friends on the independent director side, on the lender side. there's other issues too, but I'll let you guys chime in on what you see.
Okay, Mark, what's your take?
Well, I'm a little stilted on this because I haven't found a borrower objection to any of this that's not shady. So my general view is that what they're doing is shady, but it's compounded here by the fact that you've got this mezz lender in the mix, and the fact that there may be some insider dealing between the mezz lender and the borrower is certainly problematic. And I think that's something that the attorney should be mindful of. One of the other things to keep in mind is that we're, as Matt alluded to, your day before there being a foreclosure auction. So if the borrower were to choose to throw this into a bankruptcy proceeding, you have some potential issues. You have potentially a bad faith filing. You have other reasons to potentially dismiss that bankruptcy or otherwise maybe convert that bankruptcy if they file it as an 11. Perhaps maybe it should convert to a 7 and go ahead and sell the thing anyways. So I think there are a healthy dose of issues here. One thing to keep in mind from a lender perspective, from a lender ethics perspective, is that with mezz, there are often notice requirements before you put this into a foreclosure. It would be important to double check the file and ensure that you've provided adequate notice to the mezz lender prior to starting the foreclosure process. And there could be some potential ethical pitfalls for the lender here, just given the complex capital stack.
Okay, Samantha, what are your thoughts on this case study?
Yeah, I think Matt and Mark did a really good job. The only other thing I would add that one of the developers knows that the comparable hotel sale is unlikely to close, and they should probably not use that price, sale price to justify any valuation of the property, or try to argue that the senior lender is oversecured. Again, it's another sort of misrepresentation by omission if they know the sale is not viable. And if you file any court documents talking about that sale, that could be a problem for the attorney as well, if the attorney if they know or not, so it's sort of there's an ethical issue there as well.
Okay, well, let's spin the wheel here and change the fact pattern. What if counsel for the borrower learns that the independent manager is a retired executive from the mezz lender? The independent director recently sent an email demanding that he be notified of all board meetings, formal or informal, on the minimum required 10 days notice under the operating agreement. Mark, how does this change things in your view?
Hopelessly conflicted. You've lost all independence. We would seek to disregard and/or remove the independent director and proceed with our remedies. But the fact that the mezz lender is in cahoots with the borrower, or potentially in cahoots with the borrower, creates all kinds of problems. I also don't love that sitting in the position of a senior secured lender representation. I don't love the fact that the mezz is trying to massage the process such that they might get some adverse advantage that may or may not violate the intercreditor or the co-lender agreement. So lots of massive red flags here. I also think that the independent director, who's going to have their own insurance and have their own policies in place, has some potential liability here. I don't think they can truly show disinterestedness. I don't think they can really be involved here.
Samantha, what do you think?
Yeah, I agree. I think there's some scrutiny required here. The independent manager has to functionally be independent, not just independent in name. And I think this connection definitely undermines the optics and, risks neutrality here. I think a court would, if the court was examining this, they'd want to know, why is he actually doing this? Is he trying to follow his, governance, rights under the agreement? Is he trying to protect himself, showing, he tried to exercise oversight? And, if I'm the debtor, this sort of demand would slow down the decision of a bankruptcy and, would provide the mezz with more advanced notice of a bankruptcy file. This would effectively prevent an emergency filing. So, yeah, I agree with Mark. There's all sorts of issues here.
And Matt, what do you think?
I think the bad boy guarantee also presents an interesting issue for the independent mezz lender director. It's in the best interest of the mezz lender for the debtor to file a bankruptcy case, because that then triggers personal liability on those other parties. And so, is that fact playing a factor in that independent director's decision whether to promote or oppose a bankruptcy case? Maybe, but that's where the conflict comes in that others have talked about. Is it's I think hopelessly conflicted is what Mark said, and I think that just makes it even more hopeless.
Okay, well, let's do one more spin of the wheel here. What if the developer has recently received an unsolicited, all-cash, no contingency offer from a major national hotel chain for a price that would pay the project level mortgage and all of the trade debt and property taxes at the project level in full, and leave excess proceeds to pay about 50% of the mezzanine debt amount, but with no proceeds for future upside for existing equity? The mezz lender is aware of the offer, and the hotel chain is also discussing buying the mezz debt from the mezz lender. The developer wants to file a Chapter 11 to try to keep control of the property for its future upside. The mezz debt wants to try to negotiate for a higher price from the hotel chain, but is willing to accept the existing price if the hotel chain won't increase its price. Sammy, how does this change your look at this case?
So based on this new fact pattern here, there's a clear value maximizing sale, exit option on the table, and everyone knows it. So, the offer would pay the senior lender in full, the trade debt in full, and provide meaningful proceeds to the mezz lender. And the mezz lender seems to be good with this. So, the key point here, I think, is that, when a company's in distress, they owe a duty to their creditors. It shifts from the equity holders to the creditors. And so the owners of the company would have a duty to seriously look at this deal and think about whether, is this the best scenario for our creditors, which it seems like it is. And if they don't accept it, or, they'd have to show in bankruptcy, why they did not accept the offer, and if they don't, it might look like a self-interested delay. They're trying to preserve equity value over enterprise value. So I think they need to make a very clear record for any decision they make, for business judgment and board meetings, and show they got advice from professionals on, whatever decision that they make here.
Thanks, Sammy. Matt, what are your thoughts on this new detail?
I think this is one where the party pushing the foreclosure sale is the primary lender, who's going to get fully paid off with this offer. And so this is one where I think, look, if I've got a binding no contingency offer, at this point, I'm the attorney calling up the primary lender saying, hey, look, will you guys postpone your sale for 2 weeks? We'll get you fully paid off, and you won't have to foreclose on anything if we can just get this in place and close it. And at that point, it's something solid that I can send to that lender. There's a good chance they'll agree to postpone it a couple of weeks because they want cash. They don't want the crappy hotel chain. And so, yeah, that's a factor that I think drives the case a whole different direction. Now, it's not a bankruptcy case, but the borrower should be happy with that, because then it doesn't trigger recourse under the mezz loan if they file the bankruptcy. All they're losing is the potential upside, but with that offer, there is no potential upside. So what are they trying to hang on to it for?
Sure. Mark, anything else to add?
Borrower's counsel needs to dance on the head of a pin here, because if the borrower's attorney throws us into a bankruptcy to try to potentially cram folks down and create some cushion here and triggers full recourse against the guarantors, you have a major issue, especially given the value is less. I would come in and sue your guarantor and collect any of that difference. So it's you now have a potential conflict between your borrower group and your guarantor group.
Okay, and let's go back to the model rules on slide 25. Sammy, how do model rules 3.4, fairness to opposing party and counsel, rule 3.3, candor toward the tribunal, play in here?
So, like the title says, the primary concept of rule 3.4 is fairness. And, fairness matters, not just legality of what you're doing. And, as we talked about just now, there might be an argument here that the company if they file bankruptcy, is trying to obstruct creditor rights. If they have a good sale offer on the table, there's a value maximizing sale option, and they're just delaying that sale to allow equity to hold on a bit longer. When, if they file bankruptcy, there might not be a higher and better offer. So it's not per se illegal for the company to do, but the lawyer has a duty to refrain from, like Rule 3.3 says, unethical trial tactics. So someone could argue that that's just that. And then Rule 3.3, a lawyer cannot mislead the court either by commission or omission, especially on material facts. So in a potential bankruptcy case here, the attorney would have a duty to disclose the cash offer that pays a senior lender and other creditors. And so, trying to preserve value when creditors' repayment is at risk, it might be undermined by the fact that there is another offer here. And like Matt said, the first day of the case, you file certain motions, first day declaration, dip motion, and other motions that might go to these facts and are on the record and under oath. So you just want to be careful here.
Sure. Thanks, Sammy. Well, let's go to our last case study here, which is on slide 28. We've talked about declining property values, appreciating property values, and this one is about a suspect valuation. Here's the case study. Mick and a family trust own an older commercial office building, which he bought for $4.5 million with a 50% down loan. So he financed $2,250,000. Mick acquired this building through a 1031 deferred tax exchange, and rents have increased so steadily, he was able to refinance the property to take $1,350,000 out, which he promptly used to buy a dream home on the beach. Mick needs the income to pay the mortgage on his new home, so he stopped paying the bank. Several tenants did not renew their leases in 2023. A big tech company is looking for new office space in the neighborhood, but will not lease space in Mick's building without substantial tenant improvements for tenant collaboration in social activity spaces. The bank is concerned with their local reputation and did everything they could do to try to work something out, but ultimately had no choice but to pursue foreclosure. Mick has advised the bank of the potential new tenant, but not the new tenant improvement requirements, and has claimed his property is worth $12,500,000, which is $100 per square foot, on grounds that a newer 3,000 square foot fully leased office building nearby just sold for $300,000, which is the $100 per square foot. To prove he was serious about selling it to pay off the bank, he hired his next door neighbor to sell the property and gave her a 1-year listing agreement. Neither Mick nor the broker have counsel. What are the ethical implications here? Is this clever or cagey? Mark, what do you think?
Cagey. Mick is the every borrower. If you think back to the great financial crisis, Mick is every single borrower that we dealt with during the entirety of the great financial crisis. Pie in the sky dreams, everything is great, real estate only goes up, life is good, buy a house on the beach, and forget the bank, we don't care, we're not going to pay, and oh gosh, can't believe you're chasing me down, bank, you're evil. That's the mentality, that's Mick, that is cagey. The ethical issues here are significant. The one that I want to focus on and that we haven't talked too much about is dealing with unrepresented parties. When you think back through all of the various different lines of communication that the lender's lawyer is going to have with this individual, as Sammy mentioned at the outset, there are landmines throughout. Every email that you send to this person needs to say, hey, have you hired counsel yet? To the extent that you've retained counsel, please provide me their contact information. If you don't have counsel, we suggest that you do get counsel, because right now we are in legal proceedings or pre-legal proceedings, and then you can go into whatever your request might be. But I don't know that you need to send it in every email or every correspondence, but I would make a record, if you represent the lender, to ensure that there are no issues down the road. The other piece of this that's frustrating is the 1-year listing agreement, especially given that he's not paying the bank and then signed on a 1-year listing agreement with his neighbor and his buddy. that's problematic, and the lender is going to have a lot to say about that, and potentially seek to unwind that listing agreement in favor of a more neutral broker, perhaps one that Mr. Levy can recommend.
I know a guy. Matt, what do you think?
I think this is a good case to promote the Receivership Act again. You know, the bank is worried about its reputation in the community. I think reputationally, it's going to be better for them to try and get a receiver appointed. That receiver could go to the big tech company and say, "Hey, look, why don't you guys just buy this property and build it out yourself?" If it's that big of a tech company, they probably could handle that. So I agree with Mark. I think there's some pretty suspect issues in the valuations. But even if it's not worth the 12.5 million that he says, you cut that in half, you still got a pretty good equity cushion there to pay off the existing lender. But to me, this one screams for that commercial receiver to be appointed and just get the property sold.
Thank you, Matt. Sammy, anything to add here?
Since we're here to talk about valuation, I'll talk about the valuation of the company. I don't think that that valuation of property is apples to apples here. The property was never fully leased and is newer than his property. His property is old and tenants are leaving, and he also needs to make improvements to get this major tenant to sign on. So he's essentially using a single non-comparable sale to justify value, which is misleading. By not telling the full truth about the tenant. Again, it's a classic, I think, misleading omission, and he should probably disclose those tenant improvement requirements.
Sure. Well, we are running out of time here, but we are here today to talk about the model rules. So, Matt, just real quickly, please discuss how Model Rule 4.1 truthness in statements to others and Model Rule 4.3 dealing with unrepresented persons might apply to this case.
So Mark touched on it a little bit already, but 4.1 is truthfulness in statements to others. So you can't straight up lie to somebody about something, which that one seems fairly obvious and isn't really surprising. If someone asks an attorney for specific information, they can't refuse to provide it if they have it. And I think that a little nuance in the rule too is, like, if you're aware that someone is relying on something you may not have said or provided, but that their reliance is misplaced, you may have a duty to correct them. And provide the information that corrects whatever assumption they've made. So, and then the dealing with the unrepresented persons, that's what Mark said. Every single email needs to be like, hey, look, just so you guys remember, I don't represent you and never have represented you and don't represent you. And you need to get your own attorney and tell me if you do, because if you have your own attorney, I can't even talk to you anyway. So you got to be clear that those parties know that you're not representing them. I think in this scenario, one of the spots that comes in is the neighbor guy, who's the employment lawyer, who really shouldn't be talking to this guy at all about a real estate deal because he has no business doing that. That's a competency issue. But the neighbor needs to make sure that he understands, look, I'm talking to you as your bud next door, not as an attorney who actually knows anything about real estate law. And not representing him, because otherwise Mick's going to come back 2 weeks later after the foreclosure happens and he gets sued and say, well, look, you told me to do this stuff, and then the neighbor gets sued.
The neighbor should put their carrier on notice at the same time that they take that representation. I mean, it's just a problem waiting to happen.
Exactly.
Well, gang, you're great at what you do. You're incredibly insightful. There is a whole lot more material we can cover today, including fact pattern variations, deeper dives into the model rules, and some case law that Sammy Rubin was nice enough to include in our presentation. But we will have to leave that to the audience to explore on their own, as we are out of time. So we want to thank everyone for joining us for Ethical Issues in Real Estate-Based Bankruptcies, today talking about valuation, episode 1 of 3. And we thank you for joining for another entertaining yet educational production of Financial Poise. Please look for Financial Poise webinars wherever better continuing education webinars are sold, and we hope you can join for insider leases and single asset real estate cases. Thanks so much for joining. Bye-bye.
Thanks, David.
Thank you to our panelists.